Today I'll be providing an update on termination for cause provisions. So the distinction between cause and without cause termination clauses is one of the most frequent questions I get from employers. So as we're all aware, the Employment Standards Act sets out an employee's statutory minimum entitlements. If an employee is terminated without cause, the employee is entitled to termination pay or severance pay. And as we're aware, termination pay is set out in Section 57 of the Employment Standards Act, and an employee can be entitled between 0 and 8 weeks of termination pay. And then there's also severance pay, which is set out in Section 65. And if it's applicable, it's the number of years the employee has worked divided by 12. And so first I'll be speaking about cause under the Employment Standards Act. So as the Employment Standards Act sets out the minimum floor for an employee's entitlements in Ontario, the standard for cause under the Employment Standards Act is extremely high and requires willful misconduct, disobedience, or willful neglect of duty. And so that's actually set out in Ontario Regulation 288/01, Termination and Severance of Employment. And so I've included the provisions there, but for termination of employment, it reads, the following employees are prescribed for the purposes of Section 55 of the Act as employees who are not entitled to termination, notice of termination, or termination pay. And it says an employee who is guilty of willful misconduct, disobedience, willful neglect of duty that is not trivial and has not been condoned by the employer. So just a quick note about condonation. I think we've discussed this before in previous seminars, but if an employer condones conduct, they cannot later rely on it for termination. So for instance, say an employee over the course of a year regularly takes 3-hour breaks, the employer can't turn around at the end of the year and say, hey, I'm terminating you because you're taking 3-hour breaks. If the employer never disciplined the employee or seemed to say it wasn't an issue, then you can't later rely on it for termination. And severance pay says much the same thing. So in order to provide, to prove willful misconduct and willful neglect of duty, disentitling an employee to notice of termination or pay in lieu, the employer must establish that the employee consciously did something or omitted to do something that can be described as serious or willful neglect of duty. And this comes from the Exeter and Machine Products decision. So a little bit about that decision. The employer Exeter had an employee who was a machine operator, and he produced a bunch of parts, and the substantial portion of the parts were actually defective. And the company took great pains to ensure that this employee was aware that you always had to check your parts because they were going to a big named customer. And he was previously disciplined for a similar infraction in the past. And so the court actually did find that there was willful neglect of duty because the errors were far from trivial. There was a potential compromise to the company's largest customer. There was a well-established culture of quality, and he had been previously warned that this was a very serious infraction and that you needed to perform checking of the parts, and yet he consciously decided not to check the parts. And so I have another quote there from Atlas Fluid Systems, and it says, the misconduct or neglect of duty referred to in the Act is preceded by the term willful. Therefore, it is not sufficient to merely show that the employee was indifferent, casual, thoughtless, or neglectful in the performance of or in the mission to perform his or her duties or responsibilities. These acts or omissions must be the product of some deliberate or intentional act. The employee must consciously and deliberately engage in some positive act of misconduct or deliberately refrain from performing duties or responsibilities that he or she was required to perform. And so in the Atlas Fluids case, what happened was an employee was actually incarcerated. And so as he was incarcerated, he was unable to call into work or even show up. And so the employer actually terminated him for absenteeism and failure to call in for his shifts. And he basically said, this conduct was done willfully because I was incarcerated, and the court agreed with the employee's decision or position. And so there are two general categories of serious misconduct. The first will be single acts, so insubordination, theft and dishonesty, and physical violence against another employee, for instance, which may, standing on their own, meet the standard of seriousness, As well, there will be less serious repetitive forms of misconduct, which, if handled properly by the employer, will also meet the standard of seriousness. So once again, it's important to have that progressive discipline in place, and preferably in writing. The employer, in this scenario, must have explained to the employee after each occurrence that the conduct in question was not acceptable, and that if it continued, it would result in termination, and there must be, subsequent to these warnings, a culminating incident. In addition to proving that misconduct is serious, the employer must demonstrate, and this is the aspect of the standard which distinguishes it from just cause, so the just cause common law standard, that the conduct complained of is willful. Carelessness, thoughtlessness, heedlessness, or inadvertent conduct, no matter how serious, does not meet the standard. Rather, the employer must show that the misconduct was intentional or deliberate. The employer must show that the employee purposely engaged in conduct that he or she knew to be serious misconduct. It is, to put colloquially, being bad on purpose. And so, in contrast, there's the common law just cause standard. And so when an employment contract does not limit an employee's entitlements to termination, or if there's no employment contract, as most of you are aware, an employee is entitled to the longer period of notice known as common law. And where an employee has been terminated for just cause under the common law, it's very important to note that the employee is not entitled to common law reasonable notice or payment in lieu of that notice, but may still be entitled to those ESA statutory minimums. And this is because the two standards are actually quite different. So the common law standard for just cause is actually lower than the ESA standard for willful misconduct, disobedience, or willful neglect of duty. So under the common law, employees can be terminated for just cause. And I provided some examples there for criminal activities in the course of employment, dishonesty, misconduct, gross insolence or rudeness to the employer. However, if insolence appears to be just a personality clash, the court will go to the root of behavior. Chronic lateness or persistent or prolonged absence from work, provided it's not justified for a medical reason, there is a duty to accommodate. Serious or willful disobedience or sexual harassment are just a few of the examples I've included on the slide. So the decision I'll be speaking about today in length is the Khashaba and Procom Consultants Group Limited. And so the facts of the case are the employee, Mr. Khashaba, received an email from a recruiter with Procom asking if he was interested in applying for a position with another company, Exeter. So Mr. Khashaba was currently employed but had posted his resume to the job finding site Monster. And Mr. Khashaba indicated that he was interested in the position, and he actually went through and it eventually attended an interview. Over the phone and in congratulatory emails, Procom indicated that Exeter was offering Mr. Khashaba the position, and at that time they sent him onboarding emails including an employment contract that he signed, and he returned this back to Procom. So Procom sent an email indicating that once the criminal background check was done, Mr. Khashaba could give his current employer notice of resignation. Procom later sent an email indicating that the background check was clear. 1 minute later, the supervisor of the Procom employee that wrote that email saying the background check was clear indicated that Mr. Khashaba should hold off on giving notice, as it was always an outside chance that the application didn't get approved. And Mr. Khashaba only saw the first but not the second email, so he actually provided notice of resignation to his current employer. And despite sending the congratulatory and onboarding emails, Procom actually knew at the time that they instructed him that his background check was clear, that Exeter had actually selected another candidate for the position, and it was not offered to Mr. Khashaba. And so the employment contract that Mr. Khashaba had sent, which he signed and returned, included the following provisions as part of an early termination clause. And so it reads, termination for clause, Procom may, at its option, terminate your employment immediately for cause without prior written notice or compensation of any nature. For these purposes, cause means any ground at common law for which an employer is entitled to dismiss an employee summarily without notice or compensation in lieu of notice. And it also included a termination without cause provision, and I've set it out there in the slide. In essence, that clause basically says your entitlement is the Employment Standards Act. And And so there's two positions of the parties. Mr. Khashaba argued that the termination for cause provision was contrary to the Employment Standards Act, and therefore the entire agreement, or at least the entire early termination clause, was invalid as it contained an illegal provision. Therefore, he requested his common law damages for the duration of the contract. And so the duration of the contract was between April 30th, 2018 to October 31st, 2018. And just a side note to those of you who aren't aware, if a fixed term contract does not contain an early termination clause, upon termination an employee is actually entitled to receive the wages they would have received till the end of the term. And I provided the case citation there. So in essence, the entire purpose that Mr. Khashaba was targeting the termination for cause provision was not because it applied for this situation. They weren't alleging that he was dismissed for cause. It was because he wanted to invalidate the entire contract so that he could get his common law entitlements. And Procom argued the opposite, that basically that Mr. Khashaba had been dismissed without cause, and as per the provision in the agreement, he was only entitled to the Employment Standards Act, and because he had worked less than 6 months, he was entitled to nothing under the Employment Standards Act. And the fact that the termination for cause provision was illegal, which they obviously denied, had no impact on the other parts of the clause because there's a severability clause. And so the court actually sided with the employer partially. While the termination for cause provision was contrary to the Employment Standards Act, only the provision and not the entire clause was deemed to be voided, and as such the termination without cause provision was still valid and enforceable, and so therefore his entitlements were limited to the Employment Standards Act and he got nothing. The judge noted that the employment contract contained a severability clause, although the judge actually did not rely on it, and the judge also noted that the wrong done to Mr. Khashaba was actually more sensibly understood as a negligent misrepresentation, but this was never pled, so they didn't award any damages for that. And so at first, given the unique nature of this fact pattern, the court had to actually analyze whether there was a contract between Mr. Khashaba and Procom, and the judge actually did find that there was a valid and binding contract. They found a clear and unambiguous intention to make a binding contract, and the requirement that the employee undergo a credit check and a criminal record check was not a condition that would have prevented the formation of the contract. There was an agreement and it was enforceable. With respect to the ESA cause and just cause, and so this is the main point I've been trying to drive home through this presentation, the termination for cause provision in the employment agreement did not actually comply with the ESA, as it allowed for termination without notice for conduct meeting the just cause standard under the common law, but it precluded ESA entitlements despite the ESA standard being, well, the higher standard of willful misconduct. So willful misconduct under the ESA involves an assessment of subjective intent, whereas the common law just cause is more of an objective standard. So for instance, under the ESA, you would actually look at the employee directly, whereas an objective standard looks at more of a reasonable person. And this was affirmed again in the decision. And once again, it reiterated that carelessness, thoughtlessness, heedlessness, or inadvertent conduct, no matter how serious, does not meet the standard for the ESA threshold for willful misconduct. And in contrast, prolonged incompetence without any intentional misconduct can give rise to a finding of just cause under the common law. So it also discussed general principles with respect to interpreting employment contracts. And so while the termination for cause provision included language that made it clear that the employees would not get less than their ESA minimum entitlements, this was a separate provision and it couldn't save the termination for cause provision. So despite the wording in the termination without cause provision, it doesn't apply to the termination for cause. It was a very clause by clause analysis. And where the language of the termination clause is unclear or can be interpreted more than one way, the court should adopt the interpretation most favorable to the employee, and I believe Marty discussed this in his presentation. And it did not matter if the employer actually complied with the ESA or whether the legal provision actually applied to the employee. The legality of the provision depends on the wording of the provision. So it didn't matter that the termination for cause provision didn't apply. They looked at the legality based on the words. So the final decision was that the termination for cause provision was void, as it was contrary to the ESA. However, the remaining provisions were within the clause were valid and enforceable. And so basically the court held if a provision is invalidated, only the legal provision is void and the rest of the contract remains in force. It's interesting to note that this is a Superior Court decision, so it'll be interesting to see if the Ontario Court of Appeal takes this approach. The determination of validity was based on a clause-by-clause basis instead of looking at the contract as a whole. And the termination clauses should be interpreted in a way that incentivizes the employer to draft ESA-compliant clauses at the outset. But the court ultimately decided that the termination without cause provision was still valid because the provision evidenced a clear intention to comply with the ESA. The violation of the ESA was in a separate provision, and the contract contained a severability clause. So a few takeaways. So common law just cause does not equal ESA willful misconduct, disobedience, or neglect of duty that is not trivial and has not been condoned by the employer. Make sure that termination for cause provisions are drafted to include the distinction between ESA cause and just cause under the common law, such that the ESA minimum entitlements may still be required even if the just cause standard of common law is met. Break employment provisions into separate paragraphs to avoid the invalidation of the entire clause and avoid grouping multiple clauses together. And be especially careful with grouping termination for cause provisions with other termination provisions, and ensure that the employment contracts have an enforceable severability clause. So that's my presentation. I'll be passing it back to Marty to speak about frustration of contract due to disability.